So I'll call this meeting to order at 6:30 p.m. by recognizing the traditional keepers of this land and specifically our neighbors of the Alderville First Nation with a formal territorial acknowledgement. We respectfully acknowledge that the municipality of Brighton is located on the Mississauga-Anishinaabe territory and is the traditional territory of the Mississauga. The Council of the Municipality of Brighton respectfully acknowledges that the Mississauga Nations are the collective stewards and caretakers of these lands and waters in perpetuity, and that they continue to maintain this responsibility to ensure their health and integrity for generations to come. And I have a motion moved by Councillor Butwell, seconded by Councillor Fredis. The Council approved the August 16th, 2023 planning meeting agenda as presented. Is there any discussion? Those in favor? There being none opposed, that motion's carried. Members of Council, do you have any declarations of pecuniary interest? And if so, please state the general nature thereof. And there are none noted. We have no delegations this evening. We have no statutory public meeting this evening, which brings us into planning and development reports. The first report is the development agreement on 207 Middle Ridge Road. And this was prepared by Mrs. Whiteman. Mrs. Whiteman is just coming in. Is she there now? So Renee, we're dealing with your planning report, development agreement 207 Middle Ridge Road. I'll ask if you have anything to add or highlight. Mrs. Whiteman, can you hear us? She's still connected. She's having trouble. Mrs. Whiteman, we're dealing with development agreement of 207 Middle Ridge Road, and I'll ask if you have anything to add or highlight on your report.
Mr. Chair, no, nothing to hide at this stage. Thank you.
Thank you. I have a motion moved by Councillor Butwell, seconded by Councillor Fredis, that Council receive the staff report dated August 16th, 2023, regarding a development agreement intended to address conditions of Council's decision related to the consent file numbers B20 2022, B21 2022, and B22 2022, and further the Council approve and execute the development agreement through enacting the bylaw prepared for this report. And further, that Council authorize the Mayor and Clerk to sign the development agreement. And further, that Council direct the municipal solicitor through an acknowledgement and direction agreement to register the enacted bylaw for the development agreement, including making any necessary revisions to legal descriptions, names, or undertakings as may be necessary. Is there any discussion? All those in favor? There being none opposed, that motion's carried. That brings us to 6.2. Revisions to the fencing bylaw and the rescindment of appointments under Line Fences Act. Director Walsh, we've read your report. Do you have anything to add or highlight, sir?
Nothing further to add.
Thank you. I have a motion moved by Councillor Butwell, seconded by Councillor Fredis. The Council received the staff report dated August 16th, 2023 regarding revisions to the Municipality of Brighton's fencing bylaw and the repealing of bylaw number 082, 2020 to appoint fence viewers under the Line Fences Act. And that Council rescind bylaw number 082, 2020, a bylaw for the appointing of line fence viewers. And that Council repeal fence bylaw 003, 2021, and replace it with the revised fence bylaw prepared for this report. Is there any discussion? Councillor Wright.
Thank you. Through you, Mr. Walsh, does this mean that if there's any infractions of any fencing bylaws, that it will be dealt with strictly through Mr. McGee, the bylaw officer?
That's correct. When there's an offense, then we would expect if there's a concerned party that they submit a complaint form citing the reason for their complaint, and Mr. McGee, the bylaw enforcement officer, can follow up. The alternate course for someone who feels that the bylaw is not compliance, they do have the opportunity to use the bylaw as a reference in another court or a civil court for its consideration.
Councillor Fredis.
The chair, thank you to Director Walsh. In reviewing this bylaw, first a couple of questions and then or comments or questions for clarification, and then some comments if I may. It's my understanding in reading this and in the website that you do not need a permit for a fence. Is that correct?
That's correct.
Okay. The concern then is swimming pools. The defense bylaw does not stipulate fencing required for swimming pools. Is that a requirement when they apply for a permit for a swimming pool? Because obviously the safety of little kids is kind of paramount.
Yeah, I do note the concern, and that was considered under the previous council. There was also a motion at that time for staff to investigate introducing the requirement for a fence around a swimming pool. So we looked at some past, because we have had a fencing bylaw historically here for some time. So there was some previous legal advice received in, I believe, the late 2000s. And the advice at that time from Templeman Meninga was to not regulate fences associated with swimming pools in any explicit fashion. In the event that there was a failure in that fence, and if at the same time staff happened to know of the improper fence, that the municipality would then be liable. Currently, or as per last council, when staff investigated this with through the municipal solicitor, Mr. John Ewert, he came back with the same advice. So while it was thought that naturally you would want to fence a pool and many municipalities do, that ends up being the legal advice that we received, and staff followed through accordingly. Some of the comments, I believe, through that review was that home insurance companies would be advising their homeowners in putting a pool to have that fence. And I understand some insurance companies actually have standards for fences around swimming pools. So we're somewhat reliant on that. And it might be good practice for staff in issuing a building permit for a pool to have a bit of a note there. Please consult your insurance agent regarding the need for a fence around the pool. But otherwise, this bylaw is purposely silent on that matter.
A follow-up, if I may. I'm aware of one situation where the homeowner purchased a home that had and has a pool in the backyard, and the barrier at the back was trees, but they've since been removed for new development. Now, I'm not anticipating kids to be trooping through the cornfield, but one can foresee the day when the development and construction starts and families start to move in, kids see this open yard to a pool. And I know, I understand the legal advice to the municipality, but when all's said and done, I worry about the safety of little kids not being able to resist the attraction of a pool. What do we do about that? Is it appropriate or inappropriate for me as a counselor to suggest to to the homeowner that he should be doing something for his own well-being, financial well-being? Or have I gone a step too far? Again, my concern is the little kids and their inquisitive nature. And I view this as an area of potential problems.
I don't think staff can give you advice on that particular question. I think you have to, my advice would be meander that one carefully, but perhaps the best advice to the homeowner is that they should probably be in touch with their insurance company, because I guarantee you their insurance company will tell them they should have a pool or a pool, a fence around their pool, or no more insurance. I am pretty sure that almost every insurance company will require fencing at the pool.
And that, I guess, was the nature of my question. Is it appropriate for me to suggest that to him, or have I gone too far?
I guess it depends
So
on.
it sounds like you're counseling me. It's okay to go that far.
You venture down whatever road you choose, sir.
Again, I'm just concerned about the safety of the kids in the
Yeah.
neighborhood. And I'd hate to see any of them come to harm, and I'd hate to see a nice couple face financial devastation.
Yeah, I think if you know these people relatively well as a neighbor, or whatever, I don't think offering them advice, any advice, friendly advice, is harmful at all.
Okay.
But I would concur, Director Walsh, that perhaps on our application for a pool construction, we should have just a little note that for our own sake, that we have advised locals to contact their insurance agent. That way, if anything comes back on us, we can say, well, we suggested they do so when they signed this form.
Make a note of that and follow up and put that on our forms.
Anything further from members of council? Councilor Fredis?
One other question, if I may. Reading through the draft bylaw here, there's a paragraph that talks about finished side means that the fence construction is completed where either both sides of the fence have the same appearance, where the side that is not facing the fence owner's property is free of evidence of structural components such as posts and is the most aesthetically attractive. There is a situation here in the community in the Southern Peninsula part where there's some animosity between residents over the nature of a fence, where there's an ugly dark side facing one resident's home. And the poor lady who recently lost her husband is trying to sell, and it's become a detriment to her being able to sell the place. And I'm wondering if this revision to the bylaw provides her some opportunity to appeal to have this unsightly condition corrected.
Director?
There is a section in the bylaw dealing with deemed compliance for existing fences, and that's 3.1. And the existing bylaw indicates that if a fence is in existence, that it's deemed to comply. But the added provision is now a B under that section, despite A above. Existing fences that are in non-compliance with this bylaw as amended shall be made to comply in the event that, and it lists only 3 points. One of it's in a significant state of disrepair. 2, it obstructs water flows that are common to the drainage needs of properties in the area as approved by the municipality. So we don't want fences, for example, blocking drainage where we've approved a drainage plan in the subdivision, for example. And lastly, the fence represents a risk to health and safety of a person or the public in general. So those are only exceptions to any existing fence. So if someone has an ugly fence facing their neighbor, this bylaw doesn't address that.
Should that fence fall down and a new one have to go up, it would though.
Correct.
Right. Yeah, okay. Councilor Fredis?
Just to follow up, if I may, in light of that, if the particular fence is not on the property line as suggested here in the bylaw, but is set back from the property line, does that then constitute a privacy screen, in which case a new set of provisions as entailed here would be applicable?
Director?
Yes, it very well could be. There is a definition for privacy screen in here for that purpose. Persons were constructing things that were purposely avoiding falling under the definition of fence, simply for the reason to avoid those standards. So there is some new provisions in this bylaw dealing with privacy fences, not this amended version so much as the existing version that we've had. And I'd have to see the site to know the extent of that constructed fence / privacy screen, and make a determination as to how this bylaw may apply to that or not. But presumably it would fall under one or the other.
I would recommend then that the property owner you're referring to be in touch with Director Walsh, see if there's a remedy available to them. Councillor Wright.
Thank you, through you. I just sent you a picture of that.
Anything further for members of council? All those in favor? There being none opposed, that motion's carried. Brings us to Brighton Meadows subdivision agreement, draft approved subdivision, file sub 2019-03. Director Walsh, we've read your report. Do you have anything to add or highlight?
Nothing further to add, Mayor.
Motion before me reads, is moved by Councillor Butwell, seconded by Councillor Fredis. The council receives a staff report dated August 16th, 2023, pertaining to the municipality entering into a subdivision agreement with AMR Investments Limited for its Brighton Meadows subdivision phase 1. And that council give final approval to the draft subdivision M plan for phase 1 of Brighton Meadows subdivision, comprising of 16 semi-detached homes, 12 townhouse units, and 37 single detached units, together with blocks for reserves and required easements under the authority of section 51 sub 58 of the Planning Act, and that the finally approved M plan be registered within 30 days of the date of approval. And that council enact the bylaw prepared for this report to authorize a subdivision agreement between the corporation of the municipality of Brighton and the owner, AMR Investments Limited, for phase 1 of its Brighton Meadows subdivision. And that council authorize the mayor and the clerk to sign the subdivision agreement on behalf of the municipality of Brighton, coming into effect on the date of the signatures, and that the municipal solicitor be directed to register the subdivision agreement against the land subject to the draft approved subdivision. Is there any discussion? Councillor Fredis.
Through the chair to Mr. Walsh, thank you. This indicates that this is for phase 1 of the development, which will be multi-phase. Can we expect as council that the additional phases will each come to us in due course for review?
Yes, council can expect the subsequent phases to come forward again for purposes of supportive bylaw for the subdivision agreement as may be amended for the subsequent phases. Yes, the current subdivision agreement has language in it that recognizes additional phases, and but the bylaw in front of council tonight is for one phase only.
Follow up?
To the chair, yes, I have a couple of questions. I note in here commentary that a pre-servicing agreement was previously approved in 2022, but it was never executed until very recently, and financial assurances have been received. I guess in light of something that happened on, I think it was Ward in the West End. Does this delay in them executing the pre-servicing agreement give you any pause for concern that we might be on the verge of having a similar situation in our hands where the assurance or the security had expired and there was an area left without assumption?
Director?
Through the Mayor to Council, staff aren't concerned with that issue in particular for this subdivision. The pre-servicing agreement typically deals with underground works only, i.e. pipes in the ground. And it's typically a way for the developer to be able to put less money down for their financial securities as they progress the development in phases. And the pre-servicing agreement wasn't executed fully by the developer at that time, wanting to see what the market would do. So interest rates were changing, market was changing. He felt that he didn't really want to put down a large sum of money and deposit it with the municipality if there wasn't going to be a market for the lots. So, but subsequent to then, he decided to do the full subdivision agreement. And so subdivision agreements, if there's a pre-servicing agreement involved, really just finish off the pre-servicing agreement with dealing with the above ground works. And because now you're only dealing with quite a bit less work, you're also putting down quite a bit less financial security. So that's why developers like to do the pre-servicing and then the subdivision. You do underground works and above ground works. And since he skipped the pre-servicing agreement, although he was approved by staff, by council with a lot of work by staff going into it, this subdivision agreement covers both underground and above ground work. So he's doing the full development scope within the subdivision agreement, and he's put the full financial security is required for both underground and above ground works. And instead of letter of credit, because the banks were I'm being told by the developers are really getting problematic or sticky with giving letters of credit and just how they administer them. The last two major developments, such as Butler Creek Meadows subdivision and site plan agreement. Site plan agreement we just finished off here this week, I think yesterday, and as well as Brighton Meadows, they've actually just submitted a certified check. So it's
good.
Yeah, it's the banks charge administrative fee for these. Sometimes there's a 5% interest rate or whatever, depending on the developer. It can vary. So they probably save a bit of money in a high interest environment by depositing cash if they don't have preferred GIC rates or whatever they would otherwise keep it in. Yeah, we have two major developments underway, and our securities are cash.
Wonderful news. Wonderful news. Follow up if I may.
Go ahead.
I note that this development agreement incorporates your new dust mitigation protocol, and congratulations. I think that's wonderful. If I may, can I please put in another plug for the development of vibration protocol as kind of the next phase of development for our development agreements. And the last point, and then I promise I'll be quiet, or I'll try and stick to that promise. It talks about a fill management plan, and it indicates that a significant clean fill will be needed and is desirable in keeping the housing footprints as elevated as possible. And then it says, to this extent, the subdivision of the development is exempt from the municipality's fill bylaw. I've read the fill bylaw, and I must be missing something, because I don't see how it qualifies for the exemptions that are listed in that section 3, I think it is, unless you've built it into this development agreement, and again, I can't recognize it. But I guess my concern is if there's a significant amount of fill, and I realize that you stipulate the requirement for a QP to certify the soil that's brought in, and even though our fill bylaw only provides a modest $2 per cubic meter, it appears to me that it's a source of revenue that's, particularly in light of declining development charges, that the municipality should be looking to help restore or rebuild diminishing reserves. Can you comment on that a little,
Director?
Sure. It's just the the intent here was to integrate the fill permit bylaw provisions with development agreement provisions. And there's special provisions in the agreement dealing with excess soil management. And that's where it triggers the need for a qualified person under the Environmental Protection Act to deal with the import of soils. So the site is a bit low lying, or the water table is a little bit high on the site. And so they do have to elevate it in places. And so recognizing that fill will be imported to the site, it became an issue, but it's an issue that's needed to beneficiate the land or to benefit the land in terms of the approval of council. Whereas fill permit bylaw is meant to deal with essentially vacant lands that aren't really being subject to other approvals under the Planning Act, and to regulate what soil might end up there. So the $2 per cubic meter that gets imported under the bylaw is really for a type of a security in the event that the municipality would have to go in there and manage those soils in some way, i.e. take them back out and dispose of them if need be. Meanwhile, we have, for this subdivision, we have $1.54 million in securities and cash. So it felt that the $2 per cubic meter is redundant, particularly when there's strict expectations of the developer to report through a qualified person any soils being imported. So I guess the $2 per cubic meter is as a fee. There's no real service being provided there. So the fill permit bylaw and specifying the $2 per cube is my understanding that it's meant to be a security. But we again, as I said, we have securities for the subdivision agreement and to a rather large scale. So the risk, as viewed by municipal staff, and at least, is that it's not a major risk given the securities that we have in hand, and the need for them to progress in stages to bring in the soil and to have a qualified person overseeing and reporting it. When I looked at other jurisdictions and their fill permit bylaws, not specifically for this development, for the last fill permit that was issued, the sum of $2 per cubic meter is typically a security, and I use that to assist me in interpreting our own bylaw.
Through the chair to Mr. Walsh, the sum of $2 seems to be a fairly standard number, but it's my understanding that in some other municipalities, it's actually taken in as revenue. It's not so much just a security. Their rationale being that they need to cover or recoup costs to spot check the QP reports on the soil. Now, whether they actually do that, I don't know, but it is kind of a revenue source. And in light of the amount of low-level lands here that need fill because of high water tables, and again, because of the diminishment in development charges, I wonder if that might not be an opportunity for the municipality to start to rebuild some reserves. Whether we do it through a fill bylaw application, switching from it being a security deposit, or we incorporate it into our new round of impost fees when they come along. I don't know. I leave that to your discretion and judgment, but it's just a thought I had.
Director?
It might be worth taking another look at the full permit bylaw and seeing what updates it might need to have. And it would be appropriate because the Ministry of Environment, Conservation and Parks have brought into effect excess soil regulations since the writing and passing of the fill permit bylaw that we have to administer. So it would be appropriate to take a look at that and evaluate it and see if changes are needed in light of the new regulations. And that was another reason that we have lots of controls on this site through regulation and through our own agreement. And on the matter of fees and charges, normally fees and charges have to be commensurate with the level of service delivered. So the $2 per cubic meter is actually pretty high. I think a standard tandem dump truck is about, depending on the material, whether it's coarse or fine, is I think around 6 cubes per truck or so, 6 to 10. Yeah. So it does really add up. It's not a small amount. That's why I'm thinking, unless it was intended to act as some form of not just security, but actually insurance, that we can have a full, cash on hand to remove all soil, at full cost of removal at some time in the future, as excess soil gets discovered from time to time without the scrutiny of on-site investigation at the time. But most other jurisdictions are using it as more of a security than anything else. But we can take a look at the bylaw.
Thank you. Councillor Rowley.
Thank you, Mayor. Knowing that some of the previous developments we've had lately, we've been sometimes a little slow in making sure that we stay ahead of sidewalks and plantings and thing. Will staff be a little more diligent on making sure that that happens? Will there be sidewalks in every street in this development? Will we be once again kind of working with our tree planting program that we have in place to ensure that we get some of that done?
Director?
Yeah, he's nodding, so I'm assuming he means yes, yes.
Well,
Sure.
People online can't hear him nodding.
I can bang my. Yeah, so we required a mobility plan. In fact, the school board also asked for it during their comments on the subdivision. And we do have a clearance from the school board, clearance letter. So there's some of the crescents where the sidewalks are on one side only. And the main route, I think it's on one side only as well. And we do have a landscape plan for trees in it. And in terms of timing, yes, we felt that we needed to be a little more on top of the timing of sidewalks and things. So there is some stricter timing provisions in the agreement that prior to, I believe it's 50% occupancy of any segment of the streets, that sidewalks have to be put in after that, or no more building permits. So there is more stricter timing of getting these things done for the existing homeowners.
Right.
Yeah.
Thank you for that. That's maybe we can stay ahead of that a little quicker. Parkland. We don't have a lot of parkland south of, say, the railroad tracks. Will this be a significant size? Will we be taking space in place of cash in lieu? If that were to be so, if we get a big enough space, will that park be developed as far as playground structures and those kind of things? Is that something that we would cost share with the developer? Do those kind of things just fall under the responsibility of the municipality to provide? And if so, is that something that at some point maybe this council needs to review at budget time to have more monies in place in order to have more complete playgrounds?
Director?
Sure. I think it's block 131 in the plan. It was required as a conditional draft approval to be included in phase 1. So, any owner buying a house in phase 1 will have the benefit of that block 131. And I think it's around 3 or 4 acres. And it is on the westerly limits of the subdivision, backing onto the wooded area, the environmental protection area. So there will be opportunity for playground equipment and whatnot in the parkland, of course, but not so much as in the wooded area. That's a protected area. It really meant for environmental stewardship, but probably available for some trails. And that was all done. Yes, so we have
Block 133.
133.
133.
Yeah.
Okay.
I think the parkland blocks were 131, 132, and 133.
Yeah.
And there's a walkway down to Raglan in one part. And then there's another block that connects Ontario Street with a walkway on the east side. But yeah, so it's got as a landscape plan. And so the cost of works and securities reflect that too. And under the Planning Act, we're not really allowed in terms of our parkland requirements to ask for the actual equipment. But it's common to work with the developer who may, in the interest of good relations with customers, to want to get the equipment in earlier than later. And so we'll work with that developer and get maybe some playground and equipment in at municipal cost. But while they're doing all that site prep, it kind of makes sense. So we're kind of doing that with Butler Creek subdivision now. At the suggestion of the Director of Parks and Rec, we've worked with Ella Blanc, the developer owner there, to have the trail constructed. And the Director of Parks and Rec has standards for trail construction, as we've had some good trails constructed recently in Castle Ridge, for example. So the draft plan approval was completed prior to our Master Parks and Rec strategy and plan being completed. It is asking for a minimum of 1 hectare area for a general purpose park. This is under that size, but together with the wooded area, it has other special functions. It will still make for a nice park.
Right.
There was an effort to work with them, seeing if they would be interested in doing a revision to the subdivision so that we could be in better compliance with that Master Parks and Rec plan and strategy, specifically to get a bigger park closer to Ontario Street with better access.
Right.
But they had all the design done. There's a lot of things. You can't just change one thing in a design. So there's drainage, there's utility easements, etc., all kind of working around the park at the same time. And then to get Ontario Hydro to have a change of design, that represented a major delay for them. So giving some grandfathering consideration, we felt that in phase 3 of the subdivision, there is an opportunity for some added parkland there and maybe to achieve the same criterion.
Right.
So we're cognizant of the strategy and the desire to have bigger parks and more centralized locations, and working toward that. And I think on the 11th council meeting, you might see a parkland dedication bylaw come forward as well that will help generate some additional revenues for parkland purposes, and implement some of the provisions of the parks master plan.
One more comment,
Go ahead.
maybe, that might have a question. You spoke about, and I was pleased to hear that, more about staff being aware of the scheduling, how things are done. There again, it would be good for us to be a bit more diligent about how scheduling of certain work gets done that wouldn't already impact those that are living there. We've had those concerns once again in other developments. So I was pleased to hear that you spoke about that. So I hope that through this process that we will be, as I say, a bit more conscientious of those who already move into those places and then have to deal with build and dirt and whatever. Thank you.
And just I want to acknowledge the comments from Mr. John Gooding. He had some good language for this particular agreement to reflect the experiences we had in the other subdivisions and the timing of construction of these things.
Thank you both. Councillor Botwell? You're good? Thank you. Any other discussion? Councillor Rowley?
Well, it's kind of sort of because Director Walsh brought up Butler Creek subdivision. May I just ask how things are moving along with that?
No, not tonight. You can send an email. That's not part of this discussion. Director Walsh, can you remind council and the public how many secondary units will be required in this subdivision?
To the mayor, to council, yes, there's that's a good question. I didn't mean to maybe touch on that. There's a draft condition of the subdivision approval to have a minimum of 10% of the singles and semi-detached homes to have additional dwelling units. And the reason why it's a draft condition of approval is so that they can design some lots to have a little bit different configuration so that it can be purpose-built. And of course, purpose-built is always a lot more efficient than trying to retrofit something. So they have actually identified lots for the additional dwelling units, the ADUs. So I'm afraid I didn't count the exact number for phase one, but they are actually noted on the plan. When it shows the phasing plan in the legend, there is, you'll see ADU, and that will give you an indication of which lots are going to be subject to the additional dwelling units. So that's a good contribution to the affordable housing efforts that we're making there.
Good, thank you very much for that. We've already had some discussions, difficulties, if you will, with some drainage concerns off property and with some shrub removal concerns on this property. Is there anything in this agreement that would help remedy those concerns to make sure that I do know that the proponent is dealing with the brush pile and has worked with the neighbors to mitigate any offsite drainage issues. So they've been very responsible in that way. However, the brush thing is a bit of it's a bit of an issue with me. It took 18 months. It took 18 months from the point where we noted it to the point where it started to be removed. And no coincidence, I think, that perhaps the brush pile seems to be out of the way, and now we're dealing with a subdivision agreement coming to council. So I'm just making sure that in the agreement there are available remedies for the municipality to ensure that those things don't happen again. Because of course the brush pile is in a part of the development that isn't part of this subdivision agreement tonight, because we're only dealing with phase one. The brush pile was up somewhere around phase three, and I want to make sure that should more clearing be required or the movement of dirt be required, that they're not impacting, even from a siting point of view, the neighborhood, the existing neighborhood.
Yeah, so that was a rather extended period of time before there was action on that debris. And there were many conversations with the developer about that. And there were some major equipment failures with the contractor who he had awarded the job to, electronic module in particular. And so, yeah, there was repeated reminders and including like, we don't want this development agreement coming forward without something done about the debris. And the developer has had some health issues as well that delayed things a little bit, but he found a workaround. So yeah, he ended up finding someone else who could do the job, and with different kinds of equipment than the major large chipper that was meant to do the job originally. And so for this agreement going forward, it's going to be that there's a standard set of standards in the subdivision agreement called construction standards, and there's specific provisions dealing with debris. And even though this is dealing with just phase one, the subdivision agreement is registered against the whole of the lands.
Good. Thank you. Yeah. Anything else from council? Councillor Freitas.
Through the chair to Director Walsh, thank you. It just came to me just before we leave this. It talks about waste disposal, and we had a situation recently on Rabbit Run. From what I read there, it looks like it's covered, but how do we address that if we have that similar situation and stuff is piled up on Ontario Street and Northumberland can't go in or won't go in because construction vehicles are blocking the way? Do we have a contingency plan so that I don't have to keep bothering the mayor to reach out to the county?
So that's not debris. That's actual waste management. And the concern is making sure that the county has access from the point when someone moves in or as soon thereafter as humanly possible, so that they're paying the taxes and they're getting the services they deserve, quite frankly.
Yeah, we did try and cover off the previous subdivision agreements kind of were absent something on waste services and well, for example, the original street construction standards for the subdivision agreement were not anticipating heavy trucks, but we asked that the full construction standard, i.e. the depth of granular B and the top lift of granular area B of a scale or standard that would accommodate heavy trucks, particularly thinking about the waste trucks and fire trucks. And but I believe there are some provisions in the subdivision agreement dealing with the timing of winter maintenance and of waste collection. Once it has an occupancy permit, we need to make sure there's services there. There's two options. One is that the developer enter into a side agreement with the municipality, and we do it on a fee-for-service basis. That's not the case here, although we do have some language in the subdivision agreement about winter maintenance that I think reflects that intent, at least the timing of which is when people are in their homes. For waste management, I'd have to go back into the details of the agreement to see when we have mutually agreed upon that service being made available, but they would need to deal with the county on that and make sure that the standards are there. And the timing of the first lift usually is the timing for when winter maintenance and waste management would occur.
And I think the concern coming out of the other situation is that we understand that it can take some time between first occupant and the time when services are available into that portion of the community because of the asphalt lift or the county supervisor being able to get out and inspect and lots of trucks around. I think we all understand that. I just want to make sure that, and I think Councillor Fredis wants to make sure that other neighbors aren't being impacted by the piling up of garbage on, say, Ontario Street or on Raglan Street in this case, at the end of the roadway where waste management will be able to pick up, because that's what we experienced. That's what the community experienced over at Rabbit Run for many, many, many months. Only now is in the last 2 weeks, I think, is garbage being collected on Rabbit Run curbside. And before, residents were bringing it all down to Lakeshore. And, imagine if you live across from that, big pile of garbage that is getting ripped open and spread around. And we know what happens to garbage, right? So nobody's fault, except that these things take time, and there was no mitigating clause about here's what you're going to do, or here's what the developer will do in the meantime. And so maybe too late for this subdivision agreement, although we haven't passed it yet tonight, but perhaps moving forward, we need to put our minds around who should be responsible, and maybe a private service in there with a bin for a period of time in advance of the county being able to access the neighborhood because of contractor trucks and hookups and so on and so forth. Anyone else? Go ahead.
To the chair, if I may just belabor the point a little bit. Part of the issue on Rabbit Run is the contractor trucks were not large equipments. There was a flurry of pickup trucks and trailers parked on both sides of the road. So the county couldn't get a big truck down the road. And it kind of boggled my mind as to why, because they could very easily pulled into a driveway of the house they were working on and made the road accessible. Additionally, they were piling it on Lakeshore at the end of both ends of Rabbit Run, in front of established homes, and they weren't the nicest piling jobs. And in many cases, they neglected their green tag. So the bags got left by the counting. And now the residents sitting there saying, well, what do I do with this garbage? Do I keep it for another week? I don't know who to return it to. And in order to get it out of the front of their property, they were putting a tag on it to make it go away. So they were bearing a cost that they shouldn't have had to bear. And then when they tried to talk to the developer about allowing them to deposit in the bin that he had sitting there, not 30 feet away across the road, he refused them. It's not fair to the existing residents to have to go through that. And we haven't done all the phases yet, and maybe we can't catch phase one, but I would hope that we could start to address some of that in the next phases, or perhaps make the next phases contingent on him adopting it in phase one, whether it's in the agreement or not.
I think it's probably worth, at the very least, a discussion with the developer about how to mitigate that particular issue moving forward. Councillor Butwell.
Thank you, Mr. Chair. What would be our options this evening, seeing that there are a few things that maybe we might like to discuss, to maybe put this off until some fulsome discussion has been had?
Two options, three options. One is to pass it as is. One would be to refer it back to staff to be brought back as a report at a later date with some additions or some discussion. The other would be simply defer it. But deferring it would just push it off. I think we're better off if the want is for staff to go back to the developer and have these discussions, we would refer it back to staff.
Okay. I ask because I believe I made this motion.
You did.
Okay. Would this be an appropriate time to withdraw that?
Rather than withdraw it, if the intent is to refer it back to staff, I would recommend that someone put a motion to refer the item to staff for additional comments and bring it back at a later date. Director Walsh.
I just found that particular provision in the subdivision agreement. It's number 41 on page 17, garbage collection and recycling after occupancy. May I just read it? After a final interior inspection approval for occupancy has been given by the chief building official or designate, and until the certificate of assumption has been issued, the municipality will provide garbage and organics collection and blue box recycling pickup within a particular phase of the subdivision at the owner's expense.
So it's covered.
It's covered.
Good. Good.
Good.
Is there anything further from members of council? All those in favor? Any opposed? Motion's carried. Good discussion, everyone. Thank you very much. Moving on to item 7, items for information purposes. This is the Ontario Land Tribunal file number OLT 2022-004745 with regard to a zoning bylaw amendment at the municipality. Any brief comments, Director?
Through the mayor to council, the tribunal considered evidence from myself and from the applicant's agent and from the advisor with the Ministry of Agricultural Rural Affairs, and the decision pivoted on a particular phrase within the minimum distance separation guidelines and an interpretation of it. The bit more background, the zoning bylaw amendment that was being heard wasn't a consents. Consents are no longer appealable, but it's a condition of the consents. The zoning bylaw amendment needed to be completed. The zoning bylaw amendment was appealed on the basis of minimum distance separation requirements from a poultry barn to the northwest of the subject lands, and the guidelines have two types of land use, a type A and a type B. A type A is 1 or 2 residential lots. A type B is more significant development, one being a cluster of homes, 4 or more, or commercial uses, or community facility uses, they being considered more sensitive to odor. The zone amendment caused a separation of the proposed residential uses from the existing land uses in the area through an open space zone. making, in the view of staff at the time that recommended it, that we had no longer had a contiguous land pattern, and therefore it could be considered type A. Tribunal, in short, disagreed. There are some other language in the guidelines and in the PPS talking about a concentration of development in a more broader interpretation at the landscape level. If I can describe it as that, that's not the language in the guidelines. And really quite relied on the provincial Ministry of Agriculture and Food advisor in interpreting what was going to be a type A versus type B land use. There wasn't much evidence given on the zoning bylaw itself. But having said that, that is a decision of the tribunal. The applicant is now reconsidering what they might or might not do. So at the time, there was suggestion maybe not having the eastmost lot that represented an immediate continuation of the ribbon of development along the north side of the road. And so he might come back and remove that application and start afresh. If he had done that, then it might have been more clear it wasn't a type B land use. And but I don't know what he's going to do now. He may be, but because he went for everything, the whole thing is off, and you'd have to reintroduce another zoning bylaw amendment.
Thank you for that. So council will consider a motion to repeal the zoning bylaw amendment, given that the order from the tribunal is that the appeal against bylaws bylaw 073/2022 of the municipalities is allowed, and bylaw 073/2022 is therefore repealed. So council will consider a bylaw to repeal that bylaw. Which brings us to bylaws, the first being a bylaw to exempt. Sorry, there's no unfinished business on the agenda. The first bylaw is a bylaw to exempt from the Line Fences Act. It's moved by Councillor Butwell, seconded by Councillor Fredis, that council gives a bylaw its first, second, and third reading and finally passes on this date. Being a bylaw to exempt the municipality of Brighton from the Line Fences Act, RSO 1990 CL17, does not apply to all of any part of the municipality of Brighton, with exception to section 20. Is there any discussion? All in favor? Being none opposed, that motion's carried. And Ontario Land Tribunal repealing bylaw of bylaw 073/2022. It's moved by Councillor Wright, seconded by Councillor Rowley, that council gives a bylaw its first, second, and third reading and finally passes on this date, being a bylaw to repeal bylaw 073/2022, zoning bylaw amendment for application Z18/2021, 314 Whites Road, applicant Andrew Hunt. Is there any discussion? Councillor Rowley.
Thank you, Mayor. To Mr. Walsh, just a little bit for clarification on the comments that you just maybe made. Does this close the door for any opportunity for Mr. Hunt to kind of have any kind of development on that piece of property now?
Director.
To the mayor and council, I don't believe so. There was, as long as there's a significant change in the development as proposed, then it wouldn't, and doesn't fly in the face of the tribunal, then I think there'll be an opportunity there to do something. The landowner owns another abutting piece of property to the west again, so and then it gets closer to the barn. So I'm not sure what opportunities there would be there. But his agent is familiar with MDS, working knowledge with it, and clearly has some additional insight in it now as well. And so they are, I understand, just rethinking things, and sounds like they're going to propose something going forward, but I presume it'll be a smaller scale and look differently, but it won't preclude it, I don't think.
Thank you. Any further discussion? All those in favor? Any opposed? Motion's carried. . Next is development agreement bylaw for 207 Middle Ridge Road. It's moved by Councillor Wright, seconded by Councillor Rowley. The council gives a bylaw its first, second, and third reading and finally passes on this date. Being a bylaw to authorize the mayor and the clerk to execute a development agreement between the corporation of the municipality of Brighton and Lisa Clements as power of attorney for John James Wittix in the place of the late Eva Fern Wittix for the property located at 207 Middle Ridge Road, legally described as part of lot 26. I'll start again. As part of lot 26, concession 1, municipality of Brighton, as in accordance with subsection 51, sub 26 of the Planning Act, RSO 1990, chapter P 13. Is there any discussion? All those in favor? There being none opposed, that motion's carried. And the next bylaw is with regard to Brighton Meadows Subdivision Agreement, AMR Investments, sub 2019-03. It's moved by Councillor Fredis, seconded by Councillor Butwell. The council gives a bylaw its first, second, and third reading and finally passes on this date, being a bylaw to authorize the mayor and the clerk to execute a subdivision agreement between the corporation of the municipality of Brighton and AMR Investments, Inc. regarding phase 1 of plan of subdivision file number sub 2019-03. On a property located in parts 1, 2, and 3, Plan 39R 11840, Part 1, Plan 39R 9894, part of Part 1, Plan 39R 10910, part of parts 1 to 4, Plan 38R 1408, part of lots 29 to 31 west of Ontario Street, Registered Plan 28, part of lots 3 and 4, Concession 1, in the municipality of Brighton in the county of Northumberland. Is there any discussion? Councillor Wright.
Sorry, I would just like to clarify what you read, line number 17. What exactly does that mean? The municipality is responsible for the waste pickup?
Director Walsh.
Sure, I didn't actually finish reading the full paragraph. That was the key part, but it goes on to say that Northumberland County is responsible for waste management. So they will need to pay the county of Northumberland whatever cost it would charge for that waste service.
The developer would?
Yes.
Okay.
So the municipality in that clause is the county of Northumberland.
Yes, but they're not part of the agreement, so we'll need to be able and willing to execute our agreement on behalf of the county in that respect.
Very well, thank you. Any further discussion? Councillor Fredis.
I guess I'm a little stuck on the word the municipality in there. I'm wondering if we're not assuming anything and we can't get the county in there, should we not be making this the developer's responsibility to do this waste collection? Rather than put ourselves in the middle of that?
I think we have to be in the middle of it because legally the county of Northumberland has nothing to do with our agreement with the developer, but I ask Director Walsh to comment.
I would concur with that statement. Ultimately, it's our arrangement with the developer, and the county is responsible for waste management. In the event that there's any problem with the county, and I haven't been hearing any on this matter, that we may very well ask them to do things through a private collection service, but ultimately that waste will then go to the county as well. And if the county wants to make that arrangement, then the county can make that arrangement through this agreement.
You look like you may have a comment or a question before I call the vote.
I'm going to live with it the way it is. We'll see how it turns out. I have my reservations. And I think at some point we're going to have to dictate that they retain a waste management firm to collect this stuff until we get to the point of assumption and the county is fully comfortable with servicing the area. I see us setting us up for more phone calls.
It wouldn't be assumption because we haven't assumed. We often services begin well in advance of assumption, right? So it's just when the county is able to safely collect waste, or their contractor is. Anything further for members of council? All those in favor? Are there any opposed? The motion's carried. And the next is the revised fence bylaw, moved by Councillor Fredis, seconded by Councillor Butwell. The council gives a bylaw its first, second, and third reading and finally passes on this date. Being a bylaw to provide for regulating and governing fences and privacy screens in the municipality of Brighton as revised. Is there any discussion? All those in favor? There being none opposed, that motion's carried. There's no one on Zoom. Does the one person in the gallery have any questions with anything on tonight's agenda? Thank you. So before I read the item to go into closed session, we will take a let's see here, what's the real time? Take a 4-minute recess.